welcome to In the Name of the Law, with your host, Liisa Speaker from Speaker Law Firm. Joining her today is Sinas from Sinas Dramis Law Firm, Amy Bailey from Bailey and Terranova Attorneys at Law, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Good morning and welcome to In the Name of the Law, a legal talk show sharing real-life stories. Today's episode has to do with changing laws and how they impact your life. Stay tuned.
In the name of criminal defense.
I'm here with Chartier Nyamfukudza, Mary Chartier, and Bob Hendricks. So it seems like there's been a pretty big change in the legal landscape affecting criminal defense with the recreational use of marijuana. What do you have to say about how that's going to affect people's lives?
Well, the changes in marijuana, this is the biggest change in the area of criminal defense in the last, 10, 20, 30, 40 years. I mean, we've just never seen this big of a shift in criminal defense. So now for individuals, they'll be able to use marijuana if they're over 21 without that threat of prosecution hanging over their head.
So does this mean we're going to be seeing marijuana sold throughout the state of Michigan in towns and cities?
Well, the law allows each municipality, and there are 1,750 municipalities in the state of Michigan, to decide whether or not they will allow adult recreational marijuana production and sales and that sort of thing in their jurisdictions.
And I think I've heard that the state of Michigan has developed its own department or division to handle applications. Can you tell us a little bit about that?
Yes, it's called the Marijuana Regulatory Agency. And the Marijuana Regulatory Agency is a division of the Department of Licensing and Regulatory Affairs. And that agency administers both adult recreational marijuana regulations as well as medical marijuana.
Well, I'm glad you brought that up. Takura, is medical marijuana going to be a thing of the past now that we have this recreational use law?
No, I think that will continue. And there's certainly other aspects of the law that won't change. For example, driving. Driving under the influence of marijuana has never been allowed and will not be going forward.
Is it still going to be the zero tolerance with, you couldn't have any remnant of marijuana in your system like you could under the medical marijuana law?
No, so under the medical marijuana law, it wasn't zero tolerance. It was zero tolerance for someone who was not a card holder. If you were a card holder, it was under the influence, which means a substantial and material impact on driving. And that was a case that was at the Michigan Supreme Court called People versus Kuhn. The same standard under the influence is in MRTMA, which is the new recreational marijuana law.
And is that the same standard as alcohol?
No, so alcohol, there are different facets of it. So you've got the blood alcohol and then you have the impairment. So it is a slightly different standard, although the under the influence standard actually stemmed from alcohol law decades ago.
So other than driving under the influence, is there really going to be a reduction in prosecutions regarding marijuana in Michigan?
In the state of Michigan, I think so, don't you? I think so.
Absolutely. It's a short answer, yes.
Right.
What about the federal government? Are they still going to be prosecuting people for using marijuana in Michigan?
They are and they have been. So fairly recently there was a major federal prosecution of a dispensary owner.
But I would add that generally, if people within the state of Michigan are complying with Michigan law with regard to marijuana use and production, that sort of thing, generally the federal government is not looking at that. They're really looking at activity that goes outside the bounds of what Michigan law allows.
I agree with that. And then there's also a lot of facets to federal prosecutions in terms of what funding source that they can use. So when you have to defend someone in federal court on a marijuana charge, there are a lot of different motions that you may want to bring and a lot of different issues that you've got to address.
Indeed.
So under the medical marijuana law, there was really specific rules about if you had a medical marijuana card, how many plants you could grow and how it was supposed to be contained. Is that different now, or how does it apply with the recreational use?
Well, MRTMA, the adult recreational law, does establish limits on how much a person can possess, how many plants a person can grow in their licensed facility. So there certainly still are limits and regulations on the amount of marijuana and the types of marijuana.
And it's important that 21 is the cutoff age. So if you're 18, then you can't possess or use at all.
Okay. So a lot of people, I would think, have been convicted in the past for recreational use of marijuana. What happens to those people who either have convictions on their record or maybe even still sitting in prison today? Is there a way for them to clear their record?
There are a few bills pending on expungement specifically for marijuana, but right now nothing has passed. So hopefully it will. From what my research has shown, the governor and the attorney general are very supportive of expungement bills, especially for individuals who had convictions that now would be legal conduct. So if someone has a marijuana possession, for example, or a marijuana usage. So hopefully there will be a way for individuals with prior convictions to get that expunged. I mean, it makes a big difference when you look for jobs.
Absolutely does, even places to live. And I know that some individual counties, prosecutors have decided to do something different than they would have normally in terms of how far they'll go back to help somebody expunge.
It's a really exciting area of the law. So, I mean, Bob does business law, and you've been a business lawyer for years, and then now you're focusing on this area, and I think it's just really fascinating. I mean, this is conduct that just years ago was illegal. We would be defending these folks, and now we refer them to Bob to help them start their lawful business. I mean, it's just a really fascinating time.
It is indeed. It's been one of the most exciting times in my 3+ decades career of kind of seeing the transformation of behavior that was completely illegal being transformed into licensed, regulated behavior, which hopefully will help us eliminate the black market in marijuana.
Right. And so is that also going to be a benefit with taxing authorities and bringing in income for the state?
Sure, we'll have taxation on one side, and we will be relieved of the obligation to prosecute these cases, to put people in prison or jail, to have the social consequences of their prosecutions. All of those I view as significant benefits of the move toward the repeal of prohibition of marijuana.
And when you look at the benefits of cannabis, so cannabis has been studied so much over the years. Frequently you'll hear people say, oh, well, you know, we need more research on it. There's more research on cannabis than many prescription drugs that exist right now. So, and the federal government actually holds patents where they talk about how helpful marijuana is to certain medical conditions, yet they say there's no medical benefit. So you have that real dichotomy there. But when you really look at the medical benefits for people, this is, I think, a very positive for our state.
So it seems like the big lesson is, for people who use marijuana to follow the law, make sure they're staying within the confines and not drive under the influence.
Correct.
And everything will be fine for them as long as they do those things.
Correct.
So, great.
Right. So, and if people are interested in learning more about marijuana law, you can listen to our podcast, Constitutional Defenders, which is on iTunes. And you can also check us out on our website, cndefenders.com.
Thank you so much for sharing this great topic.
Thank you.
Thanks, Lisa.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC. In the Name of Family Law.
I'm here with Erica Terranova and Amy Bailey of the Bailey and Terranova Law Firm. They're family law attorneys, and I wanted to ask them about how laws have changed in a way that impacts family law. What's the biggest change in the past year affecting family law cases?
Lisa, what I would say is the new law regarding spousal support. There was a change in the U.S. tax code concerning spousal support payments. Prior to 2019, they were included for the person who was receiving support. It was included as income, and it was tax deductible to the person that was paying the support. After 2019, now that is not the law anymore, and it's not included and it's non-deductible. If your agreement was made before 2019 and you subsequently have a change in spousal support payments, that continues to be the old law where it's includable as income, deductible as income, unless it's specifically stated in the new agreement.
So just to be clear, if you had your divorce in 2018 or earlier, you're still going to be bound by the old tax law about deductibility.
That is correct, Lisa.
Okay. And then going forward, what advice do you have for people who are in the process of getting divorced right now? How is this really going to impact their lives?
Well, Lisa, what we're finding is the higher income divorces are less likely to pay as much in spousal support now because they can't deduct it. The payer can no longer deduct it. So we're finding that is having an impact on settling some of the higher income cases. we have noticed that with the spousal support guidelines, those are taken into account the new tax law, so it's a little bit less spousal support than what it was prior to 2019.
We used to be able to use the fact that you could deduct spousal support in our negotiations, and it was a plus for the person that was the payor because they thought they were getting kind of a gift because they would be able to deduct it at the end, but that's no longer the case.
So do we see anything down the road? Is this tax law going to change again? Is this going to be the reality for the long term?
At this point, this is what we have, and it's hard to determine. That law, I believe, was in effect for 75 years prior, so we don't know if it'll be another 75 years before it changes again. I guess we'll have to see.
So what are you doing to try to wrap up some of these divorce cases when you don't have that tool that in your toolbox that you used to have to settle the case?
We were very busy wrapping up cases in 2018 because that was the incentive, so we could still use the deductibility clause, but now, that gift, so to speak, is no longer there, so there really isn't any incentive to do that any longer. So it's now just more of the negotiations that we would normally do.
And is the reality for the spouse that needs the support that they're not getting as much support? Is that something that you said was going on?
I'm not seeing that in all of my cases, but in the research, that is starting to be the trend, that the recipient of the support is receiving less.
Now, is this tax law only applicable to spousal support, or does it also affect child support?
You cannot deduct your child support payments, and the person receiving them does not have to include them as income.
So that's the same before and after 2019 law?
That is correct.
And that is what has been an ongoing misconception by people. They do think that child support is deductible, but it never has been.
Okay. Now, switching topics a little bit, earlier we were talking to Mary and Takura about the new marijuana laws, and I was wanting to hear from you if the new marijuana recreational use law is impacting family law cases in any way.
Oh, it certainly is, Lisa. I always equate it to alcohol. Alcohol is legal. You can drink it as long as you're 21. You can drink it in your home. You can't drive after consuming alcohol, but as a legal adult, you can do those things. However, the courts have always protected children, and if there is a parent that uses too much alcohol while they're taking care of their children, they don't like that, and they set parameters, and the court is going to be watching you on that. They're doing that with recreational marijuana as well. We're finding that while the court can't hold it against you if you're using marijuana, since it is legal, they are putting restrictions in orders that state when you can use it, not to use it in front of the minor children, your paraphernalia or your equipment that you use cannot be laid around the house. So the courts are still looking out for the best interests of the children, and they are putting parameters in their custody orders for these parents to follow.
Have you noticed any change maybe in the past few years, because we've had medical marijuana for quite a few years now? Have you noticed a change in how the judges look at marijuana use compared to 10 or 15 years ago? Are they more accepting of it if it's consumed within the parameters allowed by the law and within a court order?
I think they all know, obviously, that it's legal. But again, as Erica said, people that come into our office and you're questioning them about their marijuana use, and they're like, hey, what do you mean? It's legal. I can do that now. Yes, however, a judge is watching, and the kids are of utmost importance. What is in their best interest? And somebody that's so stoned, that cannot care for their children, just like with alcohol use, that's a big no-no, and judges are not going to allow that. They never have.
Right. So all these changing laws, a lot of people have been divorced or they have custody orders from years ago. When the law changes, is that impact the order they have right now? What happens? Can they just automatically get it changed to accommodate the new law or reflect the new law?
No, in regard to property settlements, when you're dividing your assets and debts, the goal is for it to be a fair and equitable division at that time. And you either reach that settlement through agreement, through the parties, or you have a trial in front of the judge. Again, the judge has to use the same parameters. It's a court of equity, so they have to be fair. So if a law changes as far as something regarding division of pensions or retirement benefits, that doesn't mean that you can go back and change the agreement you had previously, because at that time it was determined it was fair and equitable under the law.
When the judgment was entered.
Correct.
So what about how do these changing laws impact? Well, let's talk about support, spousal support or child support.
Well, we did mention with spousal support the new tax law and how that might affect it if you go for future modification. As far as child support goes, the court looks at what are called guidelines. They put information into a computer program. The guidelines change every few years, and that's not enough to just simply say, I want to change my support amount because we have new guidelines. You still have to show to the court that there's been a change in financial circumstances.
And lastly, with a custody order, if there's a change in the law, can we just go change a custody order?
Again, the court is bound by looking at the best interests of the children, and that is their guide. So simply because the custody changes to mandatory joint custody or presumption of joint custody is not enough just to go back into court. They still have to look at the best interests and see that there's been a change in circumstance.
Well, thank you.
In the Name of Family Law is brought to you by Bailey and Terranova Attorneys at Law. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
Good morning. I'm here today with Steve Sinas, a personal injury attorney at the Sinas Dramis Law Firm. So the Michigan enacted the No Fault Act in 1973, but this year there's been dramatic changes in that act. And Steve, I understand you were on the forefront of the battle regarding those recent changes as an attorney for the Coalition Protecting Auto No Fault. Can you tell us a little bit about what happened?
Yeah, I'm really happy to be here, and I hope we can cover what happened. There's a lot to talk about, okay? So I think the best place to start is my perspective as a personal injury attorney. Now, I know there can be some stigma out there about what we do as personal injury lawyers, but the reality is that a personal injury attorney should be looking after someone who's been seriously injured and trying to pursue all their rights and remedies and insurance coverage available for their injury. And the thing about the original no-fault law is that when I was able to meet with a family and one of their family members was seriously injured and tell them about the rights that were available under the no-fault law, there was this sigh of relief, because what they heard was that the law said that their loved one will have whatever is reasonably necessary for the care, recovery, or rehabilitation of the injuries. And that resulted in families who had a family member paralyzed, severely brain injured, having these benefits that were truly for life and that covered everything that was reasonably necessary. No more, no less. And so when I'm talking to people about these changes in the law, they have to understand what they had. And it's a hard thing for people to totally comprehend. But the reality is that these changes fundamentally change that right that I was just talking about for so many people.
So can you give us some examples of how the law changed?
So the changes in the law are so vast and cover so many different issues. I just want to try to focus on the ones that might matter the most to everyday people. First of all, the changes in the law say that as of next July 1st, 2020, people no longer have to buy that no-fault coverage that covers whatever is reasonably necessary. They can buy something less, or some people can opt out entirely. So some people wanted the choice, but the reality is that their choice is going to lead them with less than what they need if they're ever seriously injured. That's one major change. The other change is that for various groups of people, such as children and other types of people who are injured in motor vehicle crashes, they no longer have that right that they would have normally had under the law. They're going to be subject to whatever limited policy their parents buy. And so, one thing to think about in terms of this whole discussion of no-fault insurance is how it relates to the greater issue of health insurance in America. And that's what I think people really struggle to connect. And the reality is that we know health insurance in America is an overall broken system, or a system that doesn't operate the way it really should for those who are in the most serious need of health care, or for many of those people. And personal injury attorneys are supposed to help people with their rights to get that extra coverage. And so I am just lamenting the fact that, for instance, children who are playing in the street, whose parents buy the cheaper policy next July, and they're paralyzed, they're no longer going to get whatever is reasonably necessary for their care, recovery, or rehabilitation. They're just going to get whatever limited policy their parents bought. And it's those types of people that I think are the real losers under this law.
So, I think I heard one of the things that was the selling point for this new law was that it was to save money because auto insurance rates in Michigan were so much higher than elsewhere. But it sounds like there might be more of a societal cost that wasn't considered. Can you talk about that a little bit?
I can talk about both, the savings that people are going to see in their premiums and the societal cost. So there are legislators out there are people out there who are supporters of these reforms saying it's going to lower the cost of your insurance. It may lower the cost of your total insurance, possibly. But what the law says is that only lowers one portion of your insurance, your no-fault insurance. There are other portions of your coverage. And in fact, the other changes they made in the law are going to cost more, result in your other parts of your policy costing more. So there could be offsets in terms of whether people actually see a reduction in their premiums. Now, the societal effects, the Medicaid budget has already been projected to increase, going to be increasing significantly due to the fact that people aren't going to be fully covered. And I think we're going to see a bigger hit than they're even anticipating because the cost of medical coverage for seriously injured auto accident victims is enormous. And we had a system, it was a private insurance system, the no-fault insurance system that covered it all, and now we don't have that anymore. And I think the taxpayers of Michigan are going to be the ones flipping the bill in the long run.
So I guess that leads me to two questions. What are the recourse for injured people now that their rights are limited, both for the people who have been injured previously that were benefiting from the protections of the prior No Fault Act, and then I guess recourse for those people who are injured down the road under the new law?
So let me go back to the issue of what our rights were under the old law. We all had the right to have whatever is reasonably necessary for our injuries. We also had the right to not be sued for medical expenses that somebody we may accidentally injure has to incur. We didn't have the liability for that because they had their no-fault coverage. So now the remedy that these changes offer is that for those who are limited in their no-fault coverage going forward, they can try to pursue their uncovered medical expenses from the at-fault driver. They actually have that right. Now, that's better than not having the right, but here's the reality. At-fault drivers are going to have a limited amount of insurance, so it's not going to be a full coverage situation in most serious injury cases. And then the other thing is that liability insurance is going to cost more. So getting back to the reductions, because we all have this additional exposure for medical expenses, we're going to pay more for that portion of our insurance. And that's where I see it not making sense in terms of a solution that doesn't cause more problems than it solves. I think it does.
So what should Michigan residents think about when they're going to buy insurance now after July next year?
I think they have to think about what coverage they really have, and they have to listen to people who know about what you really need if you are seriously injured in an auto accident. And it usually exceeds your health insurance coverage, what you have through Medicaid, what you have through Medicare. So you really need to think about that, because I can't tell you the devastation families feel when suddenly they've been seriously or catastrophically injured in an auto accident.
Can you tell us a little bit about the process of how this law changed?
Well, that's the thing. The process was not the one that I would like to see in democracy. I was heavily involved with the process. I was hopeful legislators were listening to all sides to find a sensible solution. It seemed like for a few months maybe they were, but all of a sudden in May they pushed these bills through at 2 a.m. They're pushed through the governor's office. Everybody says yes. And I actually remember I was sitting on the Capitol floor an hour before they voted on the bill. And the bill had just, the version of the law that actually passed was just released within an hour before they voted on it. People were sitting on the Capitol floor. I was sitting there with my father trying to interpret 120 pages of a statute an hour before they vote on it. But yet they still voted on it, they passed it, and lawyers looking at it can see all the problems, all the drafting errors, all the ambiguities, all the head-scratching things they did, and it's just not how I want to see the process unfold.
Well, thank you for sharing the information, Steve, and I know you're going to be having more information available, resources for people that we're going to share through the program.
Yes, and our website too, which will get the information on the screen here.
Thank you.
All right, thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
So after hearing the segments today, as attorneys, we really have to keep up with the changing laws if we want to do a good job representing our clients, because things are changing fast and all the time. Folks, do you have anything to add to that?
Well, one thing I think about is you have the change and then you have the effect, right? So the change happens when the legislature passes a new law or a court decides a case. But then the effect is something that we all feel in representing our clients and that the people end up experiencing way after the change actually takes place. That's what I see is going to happen with the no-fault insurance law. This happened, but the effect is going to be something that families see play out over the next many years to come.
And then with marijuana law, you can imagine the impact of that. So there are some people who are thrilled with the legalization of marijuana. There are others who are outraged with the legalization of marijuana. And now you have what was criminal conduct now is legal. So for criminal defense lawyers, it's fascinating because we're watching this play out. People who we would have represented at one point are now starting lawful businesses. So it's just a very exciting time.
And expounding on the marijuana law, the change in family law, I believe that's had a huge impact on custody cases. We now have the people that are saying, well, it's legal, so why can't I just smoke marijuana all the time? But then on the other hand, our judges and attorneys are indicating to clients, you have to be careful. You still have to be a responsible parent. And so we need to see the impact that it's going to have overall on, I guess, future parenting of these children.
So how do regular people keep up with these laws that might be directly impacting their lives? I mean, what can they do to keep informed?
Well, hopefully the four of us are helping, and they can certainly turn to resources we have. But there's a lot of lawyers putting out good information, and people should take an interest in the law. You know, you might not be a lawyer, but hey, you're always going to do yourself better and your family better by knowing more about the law.
There's a lot of misinformation when it comes to marijuana law. So on that, I'd make sure that if you are getting any information off the internet, you make sure it's a reputable source who's telling you that, because otherwise you can really jam yourself up and get into legal trouble still.
And then they're going to be calling your office.
Right.
Hopefully not, Jeff.
And if you have a question, call an attorney. Don't rely on the people at your job telling you that this is the way it should be. Call an actual attorney so they know, and they will tell you what you should do.
I thought it was really interesting. I think, Steve, you mentioned a minute ago about different ways the laws change, whether it's because of legislation or because of a new case coming out. But there's also, with the marijuana law, that was a voter referendum, right?
Right. That
so
is
the people spoke.
Right. The will of the people, which is so exciting, I think, as lawyers to really see democracy play out. Voters wanted this change. They got this change. And I think that is the most exciting thing for us as lawyers. We see the Constitution play out every day in a courtroom, but this is it even on a broader scale. I mean, this is really voter initiated.
And the case law, that obviously that affects those of us who do a lot of appellate litigation because we're in there advocating for some sort of change in the interpretation of a certain law or trying to overturn cases that we don't agree with. But that's a really slow process too.
It is, and when you have these unanswered questions, especially in the area of marijuana law, you wait for the appellate courts to make the decisions that will then impact future conduct. So I agree. Sometimes you'll wait years for that outcome.
And it's a strange experience to tell a client, well, I don't really know what your rights are because one case says this and another case says that, and so we'll have to see. I don't like to be in that place, but that actually does happen quite a bit too.
And I bet, Amy, you would also recommend for the tax laws to go speak to an accountant as well, right?
Oh, definitely.
Well, thank you so much, everybody, for being here today. What an exciting episode to talk about the changing laws, and look forward to seeing you again.
Thanks, Lisa.
Thank you very much, Lisa.
Thanks.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.